the person is a client, whether they're a regular client or whether it's a one-time representation, the complexity and amount of skill that's involved in representing the client in the case, and a number of other factors. But there are a number of factors that lawyers have to go by as a guide that are listed in the Bar Association and ethical rules for determining what is a fair fee in these areas. When there is a contingent fee agreement, the client is generally required to pay the cost of litigation whether he wins or loses, because that is court cost or deposition fees, which has to be paid regardless of whether he wins or not. This type of arrangement generally suits best in cases where the plaintiff is attempting to recover money for personal injuries. It just historically has been done in these cases, and it's worked out better in these cases than most others. A lot of times the plaintiff or claimant may have very little money to pay attorney's fees with if he or she doesn't win. And at the same time, it may be a case where they can't come out with a lot of money if they do win. So what this does is it enables the lawyer to recover or to charge more money in the cases that he wins and to charge nothing in the cases that he loses. And this balances his fees out over a long period of time in the cases. And at the same time, it allows the client to litigate a lot without having to put much cash up front when he is cash poor a lot of times anyway. So this is a good arrangement for this type of cases. Some say that in contingent fee arrangements it gives the lawyer an extra incentive to work harder when he thinks he's going to make more money. I don't think that's a good reason, although it may work and some may have that effect. But I don't think it's a good reason, because we are honor and ethically bound to work to give our greatest effort for every client that we represent. Once we undertake to represent a client, that is what we commit ourselves to do, is give our best effort. And at the same time, we expect to receive a reasonable fee for our services as such, no more nor no less. And I think that if we test these different types of charging or fee arrangements in each of these circumstances and ask ourselves the question, am I charging a reasonable fee that has some type of reasonable connection with the amount and quality of the service which I am performing, and see that that is in effect, then it will be a fair fee. And at the same time, I think the client has a right to expect that of the lawyer as well, and to expect to not be charged more than a reasonable fee, nor expect to pay less than a reasonable fee. Do either of you panel members, Mr. Monk, do you?
No, I think you've covered it very well. I think that is the procedure I use in setting my fees, and I think that's the way most lawyers set their fees, is based on the complexity of the work and many other and the type of work to be performed. Mr. Tranter,
I don't have anything to add to what Charlie said. I thought he covered it very well. One thing though that I think is of interest when you talk about attorney fees, the question that comes up so often is, or the client will say to you, well, I want the other side to pay my attorney fee. And because you explained to them that the general rule is that the other side does not have to pay the attorney fee, and it's not a question of the loser pays the attorney fee, but there are certain cases where the legislatures of our federal government or state government has said that a person who is successful may, in those very limited cases, have his attorney fees paid. Some of these federal actions we know about where someone sues for damages for violation of his civil rights, or I can think of odometer rollback cases, things like that, where the legislatures have said you can recover fees, or maybe the state legislature has said to us by writing their laws that the mortgage company, when they have to foreclose on your house, can recover attorney fees. But as we all know, those are very limited types of cases. But the question seems to come up in our offices quite a bit, and clients are a lot of times disappointed to learn that if they're victorious, they don't have their attorney fees paid by the outside.
I think it's obvious there's a variety of matters that can cause you to need to seek the services of an attorney, and there are a number of ways that you can go about selecting one. And the important thing, I think, to remember is that you don't have to pick the first attorney that you talk with. Most attorneys that I'm familiar with will give you an interview to at least discuss your case before deciding to take the case. The client or the person seeking these services also has to remember that the only thing the attorney or the lawyer has to sell is his time, experience, education, and knowledge. So that person should expect to pay for those services. And it reminds me of a story I'm sure we've all heard where a complicated piece of equipment broke down and a technician was called in, and he goes in and turns one screw, the machine works great, he submits a bill for $100. And the client says, look, you were only here 5 minutes, how can you charge $100? He says, well, it's $10 for my time and $90 for knowing which screw to turn. And I think that's true of legal services.